Hi, everybody. So great to see you today. We are at the top of the hour. We're going to jump right in because I think we've got a really great topic about if someone does something bad to your trees in your community and you wanted to take them to court or figure out kind of evidence you need to gather to do something like that, where would you even begin? So I'm so excited to hear from John O'Neill. We like to call him the lawbarist. So we'll hear from him and he'll share more about what you would need to do. So before we do that, I am going to share a little bit more about the Urban and Community Forestry Society. So I'm going to share my screen. John, can you see this okay?
Yes.
Okay. Well, thanks again, everybody. I'm Leslie Burkus, Executive Director of the Urban and Community Forestry Society. We offer these learning series every month and offer CEUs when we do so because we want to make sure that we're promoting the profession of urban forestry and making sure the professionals who are carrying out that work feel very confident in the work they're doing. So again, an introduction to UCFS, a presentation from John about the different burdens of proof and knowing which one you generally applies to tree-related enforcement, the difference between circumstantial evidence and direct evidence, and the trier of fact. And I was talking to John before this. I'd never heard that term before, but he'll help us know a little bit more about that and which one you are more likely to encounter with tree-related infractions. So as we get started here, we'd really love to see who's here. Drop your name in the chat and where you're from. We have people from around the world who come to these learning series, so let's hear who you are and where you're from. It's great to connect this way. This webinar is being recorded and I will be posting it later and you'll be able to rewatch or share with colleagues. ISA CEUs will be submitted on your behalf. At the end of this webinar, I will put a form in the chat where you can fill out your ISA information. So again, that will go in at the end of it, and I will submit those on your behalf. You all are on mute right now. At the end of this webinar, I will bring you off mute if you'd like to ask any questions or drop questions in the chat as we go, and we'll have time for Q&A with John at the end. So more about UCFS, the Urban and Community Forestry Society. What we do is to build the confidence, competence, and camaraderie of all professionals who manage trees and forests to create and sustain more livable communities. So let's break that down a little bit more. Really what we mean is that we want to be the professional membership home for the people who make and support daily tree planting and care decisions. Or to break that down even further, the people who are UCFS are the frontline workers who make trees happen. You are being charged with making trees grow or to care for them, and it can be really hard work. I've been in your shoes. I was managing tree planting contracts. I was trying to source trees, get them in the ground, do one call, all of that work that goes into making sure trees are healthy, all while dealing with homeowners and city council and all the things that come at you. It's tough, but it's really rewarding work. No one else can make that kind of impact like you do. So we want to make sure that you have the knowledge and community that helps support you. That's why this organization exists. A little more about us. We were founded in 1964, and we are, again, a membership-based organization. So if you are a member, thank you so much. Your dues help make things like this possible. If you're not, really hope that you'll join us when the time feels right. We are an international membership organization, and that's largely because of that next bullet point you see there. We are a professional affiliate of the International Society of Arboriculture. So we work really closely with ISA on programming for urban foresters. We will partner with them on their municipal specialist certification. Just really great partnership with ISA. Ways that if you are a member, you can plug in now, or if you're not, just to let you know how you could do so. Our City Trees publication that you see here is, I think, pretty well known. We're really proud of it. We have a great editor who makes sure we have good human interest story along with really great technical information. Like how do you keep your workers safe with these hot temperatures we're seeing? A whole story on how you might keep your workers safe during hot temperatures. City Trees is open source now, and that's because of dues paying members help us make that available to all. So now you can share it with your stakeholders or with your city council or city manager. Help them know more about what you're doing and hopefully feel more endeared to your cause in your work. Our Arborist Exchange program is a members only opportunity. It's up to $2,000 for members to be able to go see urban forestry in action. So maybe you'll hear from John today and say, man, I'd really love to see what DC is doing on this topic or anything they're doing in DC. I want to go see it in person. We would help pay for $2,000 of your travel, lodging, and food to make that happen. You might want to swap with somebody. You've become a mentor or mentee with somebody. Let's see each other in person. We would help pay for that swap between those locations. So applications are due at the end of May. So hopefully you might find that interesting and want to apply. Our UCFS accreditation program is focused on your specific program. How could you tell your city council, your constituents, that you have one of the premier urban forestry programs? That's what accreditation is for. We had this on pause for about a year because we wanted to make sure it was fitting within the marketplace. There's a lot of accreditations going on, and wanted to make sure it was still meeting the needs for community members and urban foresters. So it has gone under review, and we will be launching this and relaunching it in the next 60 days. So if you're interested in becoming UCFS accredited, stay tuned for that, and we'll make sure to announce when it's ready to go. Our conference is coming up in November. Such a great place. If you're loving what you're hearing from the Learning Series, you get to come to the conference and hear everything all at once. Plus, you get to be with your people, which is amazing. You might feel kind of lonely where you are right now, but when you're with those who do the same work you do, there's just such power in that. So really would love to see you in Chicago. We are accepting presentation proposals right now, and I will drop that in the chat. If you've got a story to share, best practice, something that you think people would really value hearing to make their jobs easier, more effective, would love to see a proposal from you, and I'll put that in the link. And this is November 18th and 19th. Our Municipal Forestry Institute just wrapped at the end of February, but I think a lot of people might know about MFI already. This is the only premier leadership training course for urban foresters. This is not proper arboriculture. This is not proper planting, pests and diseases. This is how you grow as a leader. If you want to get more of your projects done, you want to feel more confident in the work you're doing, this is what we focus on during MFI. It really is a tremendous networking opportunity. You're with 60 or so of other peers who can help you troubleshoot your problems, your issues, and help you grow as a leader. Announcement will be made soon of where it will be. We're focusing on the West Coast, so likely California or Oregon. So we'll be coming to the West Coast and hope to see you there. Our next learning series will be on May 14th, and we're actually going to stay in the DC area for this and hear from Earl Utzler and a gentleman from Pepco, the utility there. And it's all about how the utility company and DC work together on some really challenging issues regarding urban forestry and the utility canopy, and some legacy issues that led to some downright dangerous conditions between trees and utility. As urban foresters, we want to keep our urban canopy as healthy and flourishing as possible, and sometimes that can feel at odds with utilities. So let's hear how two people made that work, and definitely keep that conversation going because I know it comes up a lot. So tune in on May 14th for our next learning series. And with that, thank you again to our members. You are who makes all of this possible. It's so wonderful to have you here and just joining with others like you. If you're not a member, I really hope that you'll join us when the time's right. We're really here to support you and make sure you feel as confident as possible in your tree care decisions. So with that, I'm going to stop sharing, and John, kick it over to you.
Thanks, Leslie. I'm going to share my presentation now. Can everyone see this?
Yep, we can now.
Leslie?
Yep.
Okay. Great. So I'm here to talk to you about evidence in tree law cases. Leslie told you a little bit about what we're going to do, talking about evidence, looking at the various burdens of proof you might find in a tree law case, and looking at the trier effect. We're also going to talk about expert witnesses, whether you should get one or not, and what to look for. We're going to look at all this through the lens of what we in DC called the tree poisoning cases, which is a series of cases we did, which, spoiler alert, involved poisoning of a few trees within the district, trees that were protected from removal. And when we're gonna walk through the story of how we first learned about the tree poisoning, and then how we collected evidence and brought what I hope would be considered a successful resolution to the case. But we'll see. Before we do that, I'll tell you a little bit about myself and a little bit about Washington, D.C. we so I work for Washington, D.C. I've been here since 2008, where I first was working on the the work crew, just driving the big trucks around the narrow streets of the city. But that wasn't satisfactory to me, so I kind of moved up and became first an arborist, and then I got a law degree from Georgetown University Law Center. And so that's what I do now, is work on enforcement specifically of the District of Columbia's special tree law. I work, Washington, D.C. is a pretty large and I think well-funded program. It has 28 arborists that work in 4 teams throughout the city. The city itself has 680,000 people, and we have 170,000 street trees. But not only do we take care of all the street trees in the District of Columbia, we also have a pretty robust tree preservation law that has us managing trees on private property as well. The tree preservation law is 22 years old, and what it does briefly is it creates 3 size classes of trees that are protected. The first, the lowest one is just undersized trees. They have the lowest level of protections. Then we have what we call special trees in the District of Columbia, which are trees between 44 and 100 inches circumference. The reason we measure trees by circumference instead of diameter in Washington, D.C. is because we wanted everyone to be able to measure their tree. Not everyone has a DBH tape at home, but everyone has usually some sort of measuring tape that they can loop around a tree. So that's why it's circumference. Usually, application of our law requires a fair amount of fluency with pi, because you're often converting between circumference and diameter. The largest class of trees that are protected in DC are called heritage trees. These are trees over 100 inches circumference, or trees 31.9 inches diameter and above. And those trees, the story I'm going to tell is mainly about protecting heritage trees in the District of Columbia. Heritage trees have pretty unique protections in the sense that they're pretty much barred from removal unless you can show that the tree is hazardous. That means it's like dead, diseased, dying, or defective in some way. Or if it is a tree that is an exempt species. And in DC, we don't have very many exempt species. We have only Norway maple, ailanthus, and mulberry, and that's it. So unless you're one of those 3 species, or if you're or unless you're hedges, then the tree has to stay in place where it is. We do allow people to relocate heritage trees in the District of Columbia, and we've had maybe about I think maybe about 20 relocations since the heritage tree classification became law in 2016. But they're still pretty rare, mainly because they're so expensive. Usually when people have heritage trees on site, they manage them by just maintaining them in place. So now what happened, I'll get into the narrative part of the story, and I'll walk you through what we saw when we saw it, and what we did to sort of collect evidence and bring a case. So this the tree poisoning cases first came to our attention when a contract arborist, a third-party registered consulting arborist even, reached out to one of our urban foresters and wanted to get their help in getting a permit to remove trees on this property. These are the development plans. You can see here that the property was entirely forested before, at the time that this permitting process was being undertaken. Most of the trees on the property, either special size or undersized black locust, There were a few protected heritage trees on the property. There were two in particular that were protected, that were heritage trees and on the property. And then there were two more that were just outside the property, and which would need to be protected if the property were to be developed. You can see from the plans that they wanted to develop the whole property and sort of fit every inch of it with a townhome. And that would necessitate removal of the two protected heritage trees that are on their property. Again, here's the overhead view of the canopy. And then here is where the critical root zones of the two protected heritage trees could be found relative to where the property is and where the development plans would be happening. So this RCA reached out to our urban forester and said, hey, we want to get permits to remove the trees. As luck would have it, all the trees are either special sized or undersized, so we can pay to remove those. Or if it's a heritage tree, like these two heritage trees you see on the site plans, they're dead, unfortunately. So, we can get a permit to remove those for free, right? And normally we would grant that, but right away, this request didn't really hit right with our urban foresters. So again, this is a story of learning that something's not quite right, and then moving on to start collecting evidence. And so right already we're at a point where we're collecting evidence to see if any wrongdoing has happened. What happened is Mark Tan, who is the urban forester in question, went to Duff McCulley, his supervisory forester, and brought this to him, saying, it's just odd that the trees, died so quickly. He had a memory of the trees being alive not too long ago. And the reason he had this memory isn't because, he was looking at that site specifically, but just because, that was his arborist zone. In DC, all of our arborists work in a specific part of the city. So Mark Tan, and in turn his supervisor, Duff McCulley, had been in that place frequently. They'd gotten to know the trees, and even though they had never had occasion to look at those specific trees on that specific site, they had an idea of what trees were there, what the canopy looked like, and whether those trees were healthy or not. And so Duff and Mark both had this sense that the trees should be healthy heritage trees, that even though they're white oaks, and we have seen sudden white oak decline in Washington, D.C., that it was very odd that two trees would disappear, would decline and die so rapidly, because they had memories of seeing them in the past few years with healthy canopies. This is now in like early 2022 that the registered consulting arborist is reaching out to our division staff and trying to get his permit, and saying that the trees died. So, they're thinking both trees were alive and very healthy as recently as 18 months ago. So, what's happening on site? And so they, went to the site, looked, and this is what they found. They found, that indeed, both of the heritage tree white oaks that were on the site were dead. This one, had a dead canopy. This is a view of tree T39. I'm going to call these trees T39 and T46, which is the numbering used in the registered consulting arborist's initial site plan survey of the property. So this is what I'll call the D Street property, and this is a view of tree T39, the tree, the white oak that was healthy in November 2019, but which by October 22, you can see from this Google Street View imagery, or sorry, I think this is Cyclomedia imagery, the tree is just entirely dead. It's lost its whole canopy. You can see next to it, just on the outer rim of the red circle, there's another dead tree which is also a white oak, which had been declining for several years before these two trees died. So you may see images of this other dead white oak as we proceed, and we'll talk about it a little bit. Our opinion was that that tree died of natural causes, unrelated to this, unrelated to what we were beginning to suspect was a tree poisoning incident. If you'll see here, you can see, again, this is the canopy shot of the D Street property, but I've circled tree T39. That's the tree in the upper left. And then tree T46 is the tree that's in the center of the photograph. And that was the larger of the two white oaks. But again, they're both very large. They're both considered heritage trees in the District of Columbia. This is what the trees look like just a year later. So you can see in tree on this slide, this is July 2020. The trees have full canopies. Moving to July 2021, the trees are almost entirely dead. And so, you know, using that imagery, and again, just using Mark and Duff's knowledge of the site, you know, we had a feeling that something, you know, nefarious was going on. And so it was we felt what we wanted to do was to investigate and start collecting evidence. Looking at the evidence we have right now, I would hope you would think that we really don't have enough evidence to bring a case. This is really just speculation at this point. If we went to a court now, all we would be able to do is say, look, these trees died really fast, you know, almost too fast for a white oak. But I would think and hope that a judge would look at that and say, you haven't told me anything. Even if we as urban foresters feel that that is meaningful to us, I don't think we would have done anything to prove our case to a judge. So what we needed to do was collect evidence. And now there's two kinds of evidence. So I'll talk to you about that briefly. First kind of evidence is direct evidence. This is evidence that ties a perpetrator directly to a crime. And so who we see here is Snidely Whiplash. He's the evil nemesis of Dudley Do-Right, the Canadian Mountie who was part of the Rocky and Bullwinkle show. Snidely Whiplash was always stealing people and tying them to railroad tracks, and he was usually caught red-handed. This is direct evidence. So if we took Snidely Whiplash to court and put him on trial, you know, Dudley Do-Right would say, I found Snidely Whiplash. I saw him with my own eyes. He was, you know, he was tying the woman to the railroad tracks right before me. I caught him. I saved her, by the way. And, you know, and so here he is, Your Honor. Let's figure out what punishment he gets. This would be direct evidence. This is not what we have in this case. Other forms would be, you know, a confession of a witness, a confession of the perpetrator, the person that's being tried for the crime, you know, testimony of a witness, photographs or video can sometimes be direct evidence. And like I said, we didn't have any of that in this case. So what we have to rely on is circumstantial evidence. So this is a little bit different. You know, this is evidence that relies on an inference. We have to connect the dots with this kind of evidence. And what we're going to see throughout the course of this presentation, over the course of this tree poisoning case, is a lot of dot connecting, because we didn't catch anyone red-handed. Unfortunately, you know, we can't be everywhere at once. There's only, like I said, even though we have a large program and we have 28 arborists, you know, we just can't be on site, and, you know, we're not going to be able to, you know, catch people poisoning trees in the middle of a wooded area. So we have to connect the dots, which is what the Hardy Boys are doing here. You know, they're looking at the footprint, these gumshoes. They're saying this footprint, you know, is made by a boot worn by the person we think is the suspect. This airport official beside them is holding a broken piece of wood for some reason. I'm not sure why, but that maybe could factor into whatever case the Hardy Boys are putting together. So that's the kind of evidence collection we're launching into now. And to do that, what Mark and Duff did was just go and take a walk around the site. There's a pretty low risk that that we would be sorry that the owner of the site would come at us for trespassing. We're really not too worried about that. I think we have an implied right to go on the site, given the fact that we're in a sort of permitting conversation with the site owner and his agent, the registered consulting arborist. So Duff and Mark made a site visit, went into the wooded area without thinking too much else about it, except for the purpose of looking for evidence. And what they found is holes around the bases of the two trees that had died. And we also looked at we also looked at other trees that were nearby. You can see in this image, you see tree T39 and tree T46 that are shaded in red. But what you can see here is also, I've marked in blue, another heritage white oak tree that was owned by the District of Columbia. So this tree is in District of Columbia right-of-way. And so it's owned by us, DDOT UFD, Urban Forestry Division. This is a tree that we manage. You can also see it marked in yellow is the canopy of another heritage white oak tree. So there are 4 heritage-sized white oak trees growing on this block. The one in yellow was on private property. And an investigation, again, done by Duff and Mark, indicated that both trees were both healthy. They still had very strong green canopies, and we didn't see holes around the bases of the trees. Whereas around tree T39 and T46, there were probably about a dozen holes around each tree, going around the trees at the root flare. Now is probably a good time. So we've collected a little bit more evidence. Not only have the trees died suddenly, but we've discovered that there's that there are holes around the tree. There's a sort of method to introduce a chemical agent or poison into the tree, which we would argue or suspect had been done in a deliberate manner to kill the trees. So now's probably a good time to talk about. We have some evidence. How much do we actually need to bring a case? How much do we need to win our case when we go to court? And for that, we have the levels of burdens of proof. You might hear some of this, especially in media related to legal narratives, especially the phrase "beyond a reasonable doubt." That's not the burden of proof we're working with here. Beyond a reasonable doubt is the highest burden of proof and is used in criminal cases. So the bad guys, Snidely Whiplash, Dudley Do Right would have to prove to his Canadian court system that beyond a reasonable doubt, assuming they have the same burdens of proof in Canada, which I can't frankly comment on. But again, beyond a reasonable doubt, did this person tie a victim to the railroad tracks? And maybe with that eyewitness testimony and Dudley Do Right's credibility, he can prove that. Usually this is thought to be over like a 90% burden. Is it like 90% or more likely that this fact happened? Sometimes it's characterized as even like 99%. Below that, we have clear and convincing evidence. This is a standard that's intermediate burden of proof, and it's used in civil cases like fraud, but also cases like punitive damages. If you're seeking punitive damages, you might have to prove by clear and convincing evidence that a fact is true, or that a particular person had wronged you in a particular way that merits punitive damages. And so the reason we have this higher intermediate burden of proof is because some things, so for example, like punitive damages, are so ruinous that that we want to be extra sure that we're apportioning blame to the right party. The most basic burden of proof is preponderance of the evidence standards, the lowest burden of proof, and all it really means is a fact must be more likely than not. So again, this is characterized as kind of a 50%. So we just have to show, and in civil cases, like basic civil cases, this is what we go by, preponderance of the evidence standard. This is what we're using in our tree cases. We just have to show by preponderance of the evidence that it's more likely than not that the owner of the property had a hand in poisoning these trees. Usually in tree cases that we bring in the District of Columbia, showing that the owner of a property was involved with the removal of a tree is not too difficult, because you have to answer the question, if it wasn't the owner of the tree or owner of the property, then who was it? And it's really unlikely that, there's other, that neighbors are coming on the property and removing trees. It's unlikely that there's a rogue, sort of timber harvesting organization that's out there harvesting trees in the urban city. So, connecting the property owner to the crime or to the tree that's removed is usually not like the difficult part of the burden of proof. Here, that's complicated though by the fact that it's that we're dealing with a tree poisoning case. Again, we don't know. We're not showing that the property owner removed the tree. Here, we have to show that the property owner developer was someone that commissioned the poisoning of the tree. And we know that they had an interest in doing so. They had a motive because they wanted to get around our heritage tree laws, which would have prevented them from fully maximizing the development footprint of the property that they were developing. But still, I think we have to do the motive alone isn't enough, to meet our preponderance of the evidence standard. One other thing, when we're talking about burdens of proof and whether a fact is more likely than not to have happened, I think the question, hopefully some of you are asking, is who decides that? The person that decides, whether you've met that burden of proof is the trier of fact. And in all court cases, it's either going to be a jury or a judge. And in most cases, that you probably see again in legal narratives often involve a jury. Here, these our tree cases don't involve a jury, they involve a judge only. So there's only one judge. The judge is the person sitting and conducting the hearing. They're running the hearing, but also making decisions on the evidence. Whereas with a jury, there's also a judge there, but the judge really only acts as a referee. They're deciding what evidence the jury gets to hear, and they're instructing the jury on how to weigh the evidence. Whereas in the case, the tree cases, including the cases that we're going to bring in this story, the judge is someone who, receives all the evidence and then decides what evidence to put is credible and what is not credible. So one last thing to think about, I didn't talk about this earlier in the slides, but DC has pretty steep penalties for tree removal. So if you remove a special tree, the fine is $300 per inch of circumference. And that comes out to about $13,000 for the lowest size special tree. So if you break the law in the District of Columbia and remove a tree without a permit, the minimum fine you can get is $13,000. And if you remove a heritage tree, the smallest heritage tree fines start at about $32,000. So these penalties are really steep. And if you'll remember, what I just talked to you about was the different burdens of proof. The reason we have that intermediate burden of proof, the clear and convincing evidence standard, is because sometimes a penalty can be so ruinous that we want to make extra sure that we get it right. And so here in these administrative hearing cases that we take, that our tree tickets go to, where we have a hearing just in front of a judge, the standard of evidence is supposed to be preponderance of the evidence standard. But I think because the fines can be so large, they can run so big in our tree cases, that the judges, whether purposely or not, kind of shade into a higher burden of proof. They might look to see if we've made our case by clear and convincing evidence. So when we bring a case, we want to make sure that we have as much evidence as possible. Like, we can be sure of something, we can feel it in our hearts, but we want to make sure that we can persuade everyone, and especially the judge, that we have the evidence showing that the person has committed a crime, or not a crime, but in this case, an infraction. And so I'm going to walk you through the evidence that we collected and see what you think. So we had these wilted leaves. Again, this was evidence that Mark and Dan observed right away when we first got to the site, and we determined that this indicated the trees had died suddenly. And so they didn't have time to create the chemical to like abscess the leaves from the stem, from the parent stem. And again, that's probably not enough for us to bring a case, but it helps. Now, this is the first moment of serendipity that we encountered when we did this case. There's going to be two that I'm going to talk about. This was really interesting for us. So this is the first week when after we discovered the likely tree poisoning, we were back in the office talking about it, and Mark and Duff were talking about this potential tree poisoning on this property with the registered consulting arborist, and another urban forester named James Biddle, who's unfortunately no longer with us because he was great and is now at Stanford University. He said, I have a property and I just issued a permit for them to remove trees on that property. So this is a totally different property, totally different location, different part of the city. And he also had just issued a permit to remove 2 trees that had just died. Now, these trees were elms. This slide just shows you that the property 2440 Shannon Place Southeast is near Metro Station. So this was a property that was currently in the possession of the District of Columbia, although it was in the process of selling it to the same developer who owned the Oaks at D Street, and it was selling it to this developer for $1. And it was District of Columbia was going to sell it so that they could put some townhomes in this area that's right by Metro Station and get more housing in the city. One of these elms was a heritage tree, and one was a special tree. You can see them there in this picture. Unlike the other area, it's not forested. It just has these 2 elms, and that's it. This is it's the same registered consulting arborist, and this is what he wrote in the permit application. Both trees are dead or near dead, likely a result of DED. And so James Biddle had gone out there, looked at the trees briefly, and said, you know what? All right, they're elms, they're dead. All right, I buy it. They probably died of DED. They're behind a locked fence, so I can't get to them. Not that that would really inform my opinion anyway. So I'm going to issue the permit. And so he did issue the permit just the very same week that we were discovering the tree poisoning, the dead trees over at D Street. This is a side-by-side again, showing the trees in the summer of 2020 and the summer of 2021. Sorry, I think that's yeah, those are the trees in 2020 and then 2021. So James went out and looked through the fence, and this is what he saw. He saw more injection holes around the base of the tree. And so unlike the oaks, which we didn't have control of, you'll remember this property was owned by the District of Columbia. And these trees had been managed by us, the Urban Forestry Division. And so we knew that we hadn't done any elm injections on these trees. And yet they had holes around the base. So again, that led us to believe that we saw the same, the same method of poisoning, the same method of injection around both trees. This is another picture showing the elms gated off. So we couldn't really get in there and take a close look at the elm injection holes. Not yet, at least. James really wanted to get in there and see, take a closer look. And so what he did was he emailed the site manager, which was this person in the mayor's office, the District of Columbia Office of Economic Development. And James said, I want to investigate some trees. They died under curious circumstances. There are trees, so can we get access to them? He got sent to another employee with better access to the site. James reiterated, I found a series of mysterious holes in these trees. So can we get in there, get access to it, find out whether these trees were poisoned or not? Instead of hearing back from the person in the deputy mayor's office, this is what happened. We went out and discovered within a few days that the trees had been removed. And so we thought this was pretty fishy. We thought maybe someone that was in the deputy mayor's office had contacted the developer, let them know that we were investigating this case, and had tipped them off and let them go onto the property. Again, this wasn't their property yet. They hadn't yet bought it for $1. This was still property owned by the District of Columbia that we should have had access to. But they did have access to it. They got on there, removed the trees. And again, we didn't catch anyone doing this, even though it was in a pretty public part of the town. We didn't catch it. No one saw them. So again, no direct evidence. We're still dealing with circumstantial evidence here. James. So what we did is we said we need to go look at D Street and make sure that those trees were not poised or were not removed as well. We went, and this is what we found. These were the holes. These were the holes that were clear before, but now were filled with debris in an effort to disguise them from detection. And so finally, this whole time that this investigation had been ongoing, we have been interacting with Pacific Agricultural Laboratories and arranging to take trunk tissue samples and send them out there for testing. And so I talked to Kara Greer from that lab, and she recommended that we take trunk tissue samples from all the trees and send them and have them tested for glyphosate, and to do another test that they run, which tests for a suite of chemicals for chlorinated herbicides. And so that's what we did. We went out and flagged all the holes, used a clean drill bit that was larger in diameter than the holes, and drilled into it and removed tree debris. Here we are measuring the holes, and then removing, we excavated that tree debris from the trunk tissue, collected it on a clean cloth, and then wrapped it up and sent it to the laboratory, which is in Oregon, by the way. This is an image of some of the debris that we extracted from the holes, that have been fit in there. And then this is the submission receipt we sent to the laboratory. We sent 5 trunk tissue samples. We also sent leaf samples that we collected. So we had some climbers meet us on site. We climbed the trees, cut some branches off, and collected the dead leaves and sent them to be tested separately. And this is the results of the lab testing. So the leaves showed traces of picloram on both trees. And then the trunk tissue of both trees showed picloram and 2,4-D. In this case, we submitted three samples, two from tree T39 because we just collected so much, and one more from tree T46, which just had incredible levels of 2,4-D and picloram. And I didn't know this at the time, but this is Tordon is a chemical, an herbicide that has both chemicals in it. And so, again, we don't know this. We're just building a case on circumstantial evidence. But, this led us to believe that Tordon had been used to poison the trees, that was infiltrated in the tree somehow. Meanwhile, James got kind of fed up trying to get access to this site. And so what he did, which I thought was pretty cool, was he went and broke one of the chains on the lock and just added his own lock to it and gave himself access to the site. He collected the stump grindings, and he tried to collect as much as he could from the periphery of the area where the trees were, under the theory that that was the area where the trunk tissue that had the most exposure to the poison would have fallen. So we collected this. He collected it, by the way, by himself. Put it, in a box on my desk, and we sent it off to the lab. And this is how it came back. So again, 2,4-D, picloram, and in this one sample, they had triclopyr as well. The other sample that we sent just had 2,4-D and picloram. So there's two other pieces of evidence that we have as part of this case. We had our own man in a dark alley incident where Duff McCulley was talking to a local arborist unrelated to the tree poisoning case. They were just doing a tree evaluation at a site he was working on. And that arborist said, I had someone came in and approached me and asked about poisoning trees. And Duff, who had been working on this site with us, asked, okay, tell me more about that. And so he managed to extract some information from this arborist where he said, we were able to confirm to our satisfaction that he was talking about the same developer that we were investigating. One other piece of evidence we collected. When we were collecting plant and trunk tissue samples from the trees at D Street, I observed, because I was the one on leaf collecting duty, that one of the trees had cicada damage and the other did not. So if you live in the Mid-Atlantic, you probably know that Brood 10 emerged in the spring of 2021 and started egg laying that May and June. And I thought it was odd that there was one of the trees had cicada scarring on it, the other didn't. That led me to believe that maybe the tree had been, one tree had been, still alive at the point of cicada egg laying, and the other had already died. So that made me think that that the poisonings had occurred in maybe June 2021. That was sort of how I narrowed it down. And I ran this theory by Dr. Casey Iturralde, who is an entomologist and who at the time was on our staff at the Urban Forestry Division. Now she's at U.S. Forest Service, helping to manage IRA. And she liked that theory. She thought it was probably correct. And so here's all the evidence. We have sudden death of the trees, the wilted leaves, the trees with holes in them, and the trees with poison in them. Some of the poison holes, that they were found on two separate properties, the same poisons, and they were filled to prevent detection. I colored the solicitation poisoning services red because that's the closest thing we have to direct evidence instead of circumstantial evidence, but even that honestly is probably circumstantial in this case. And then we have cicada damage. So I don't know how you felt about all the evidence, but I felt pretty good about it. And so we issued two notice of infraction. They were, one is for $76,000, the other for $67,000. So the developer faced a total fine of about, just over $150,000. And from there, things spun out even further. The Washington Post did an article on this case. This is a picture from the article. DDOT let us go on site to talk to the reporter, but we can only talk off the record, and they could take photographs of us, but we couldn't speak on the record, which I thought was a little odd. The developer then hired their own expert witness. The expert witness was another registered consulting arborist, but not the same one who had been involved with the project initially. And he made a few odd arguments. First, he said that, we relied on hearsay, which, is a legal term. He has some familiarity with it, but not a whole lot, because it shows that he doesn't realize that in this kind of trial, it's okay to produce hearsay as evidence. Remember, the judge is someone who receives all the evidence and then decides what sort of like weight and credibility to give to it. Then he raised the issue that in the charging document, I had said that they had used an ArborJet injector or similar system to infuse the chemicals into the tree. He said this was an assumption. He's correct about this. This was a image I included in the charging document, and I had also said in the charging document that the size of the injection holes were no more than a penny. Again, I hadn't really thought too hard about this and just wrote it, even as an estimate. And if I had to do it over again, I would definitely be more exact with my measurements. And in thinking that, instead of, an injection system having been used to infiltrate the poisons into the tree, it's also possible that, maybe someone had just poured poison into the tree in the same way that, King Claudius murdered Hamlet's father by pouring poison into the king's ear. So this is, just something that I was conclusory about when I wrote the memo accompanying the notice of infraction, which I wouldn't have done because I think the weight of our circumstantial evidence stands on its own. In this case, we did hire a expert witness of our own. That's Matt Arndt from Matt's Healthy Woods and Wildlife in Missouri. And he did a good job. I really liked the work product he put together. And he found a few things, some images that I hadn't found on my own. One thing he did, besides pointing out the fact that I shouldn't have been conclusory about saying that a trunk injection system had been used to poison the trees, was that he also found this imagery showing the trees in May 2021. These are the elms on 2440 Shannon Place. And if you look, it really doesn't look like they died of Dutch elm disease. So I thought this was really helpful. I don't know if most cases we don't get an expert witness. This is the only time we've done it. But so I wouldn't necessarily recommend it in all cases or even, most cases. But in this case, I think it was useful. As it turned out, though, we didn't really need it because I think the weight of our evidence was so overwhelming that the developer just flat out paid the fine. They paid the fine. This is the $76,000 that went to the trees on D Street, and then $67,000 that they paid for the Shannon Place trees. So, we got what we wanted, or we got, the most that we could get, but it wasn't everything we wanted because they're still, at this point in time, they're still allowed to develop the property. And I think D Street hasn't yet started development, but the Shannon Place property, they've already started building homes there. I was hoping, maybe something would happen to derail the transfer of property from DC to the developer, but it didn't happen. And so, they're getting to reap the fruits of their wrongdoing. We're able to catch them, and we're able to extract the maximum fine we could get from them. But unfortunately, there was no further penalty in that case. There's more to say. I have a lot to say on this topic, but I promised Leslie I'd leave time for Q&A, and I know we've only got a few minutes left, so I'd love to hear from you guys and answer some questions.
Thanks, John. Wow, I love all of your stories when you have the Simpsons in there and Dudley Do-Right. I don't know if everyone on this probably knows that person, so we'll have to do a generational poll. For those looking for ISA CEUs, I just dropped the form in the chat, so please fill that out if you're looking for ISA CEUs. If you have any questions, feel free to drop them in the chat or raise your hand and I will bring you off mute. And as we get going on that, John, you just kind of alluded to it. It sounds like there's nothing to do to stop this developer from doing this again. Do you just keep like an extra eye on the properties he buys, or like how is there anything to do to like stop this from happening again? Or do you think he got his hand slapped enough?
No, he didn't get his hand slapped enough. What we do is keep an extra eye on what they're doing. It's become really challenging working with the registered consulting arborist who is involved in the project. There's a lot I left out for the point of expediency in telling this story, but the registered consulting arborist, when we issued the tickets, I charged a lot of people. I charged the developer, all the LLCs that the developer owned and that were related to the properties. I charged the registered consulting arborist in his personal capacity, and I charged the company that employed him at the time. And the only one that responded to me was the company that employed him, which we didn't believe had anything to do with the poisoning, but we just wanted to cover our bases. They reached out and said, "Wait, what is going on?" And meanwhile, just radio silence from all other parties. So I just want to point out that while in the United States, you do have a Fifth Amendment right not to self-incriminate, the silence in my mind was very incriminating. And I think everyone knows that, but we still have to work with him. The same registered consulting arborist is doing projects in DC still. And it seems like every month, one of our urban foresters will come up to me and say, "Hey, is this okay? Like this arborist is on this project. Is it okay to work with him?" And I'd say, "Yeah, he's still an RCA. Still, he can still do business in the district." And so that's something, that we have.
Someone asked about an ethics violation against him. Could that have been filed?
I looked into it mainly through the ISA. The reason I didn't is because we don't have direct evidence. I thought it'd be cool to do an ISA ethics violation, but I'm not familiar with how these ethics violations work. In my imagination, there'd be a very high burden of proof. So you might remember we talked about burdens of proof. And I would think that for a private, industry organization that's gonna think about stripping someone's, credential from them, I think they would contemplate that as a very punitive measure, and I think that they would use a very high burden of proof to determine whether to do that or not. So we're talking clear and convincing evidence, or even beyond a reasonable doubt standard, whether they know they're using that burden of proof standard or not. They would employ it, even unconsciously. And I think, because of that, I just thought, I don't think we can reach that high of a burden of proof with just our circumstantial evidence. Maybe you think otherwise. Anyone honestly can reach out to me. I'll provide you all the documentation I have if you want to try to go through ethics violation.
Yeah. Well, there's a lot of questions about the actual, real quick, we're 2 minutes to the top of the hour. We'll stay on a little bit longer afterwards. If you need to drop off, this is being recorded, but we'll stay on for another few minutes if we still have questions coming in. John, a lot of questions about the testing. So one, the lab that you sent it to, what the cost is for testing, and then is there anything special you need to do to handle those samples, sterilized bags and tools? Question if that needs to happen.
Yeah, so we did try to use, we use sterilized tools and bags. The lab sent us sort of styrofoam box that had an ice pack in it and everything. I'm not sure that was necessary because when we sent and it just, it didn't have, we didn't take the same protection. We sent it, through the regular mail. I didn't get a special shipping box provided by the lab. And, we had the same results. It didn't look like there was any sort of degradation of the material. But we did our best to use sterilized equipment and storage material. As far as cost, I should have looked this up beforehand, but it was about a couple $100, I think, per sample. So, it was maybe cost maybe between like $1,000 and $1,500 to test everything, which in my mind was a bargain.
Mm-hmm.
So I would hope you would think that too. I think I saw a question flash up about other labs. We use Pacific Agricultural Laboratory because James Biddle had heard from someone that I think Bartlett used them, and that's just why we went with them. Mm-hmm. There was another lab I was in communication with at the time, and I regret that I can't remember their name. But they were pretty good too, and we had used them in the past. So this isn't our first rodeo with tree poisoning cases, and so we've sent material to be tested in the past, and at that time we sent it to this other lab, and I regret only that I can't remember their name, but they did a good job too. In my mind, I liked the lab report from Pacific Agricultural Laboratory better than the one I saw from the other lab. This one, and the director of the lab, Rick Jordan, hopped on the phone with me after we got our results and talked with me and walked me through some of the things I didn't understand. He was willing to spend his time answering questions for me, which I was greatly appreciative of.
Yeah. Again, we are a little at the top of the hour. I have dropped the ISA CEU form in the chat. I will send it again. We'll stay on for a few more minutes. Use the fine. So question, I'm going to go up to this other question I saw. Can you put liens on properties if they fail to comply? And well, let's start with that one. Can you put liens on properties that don't comply?
Yeah, so I didn't tell you the whole story of DC's evolving tree law, but this happened in 2021, and the investigation happened in 2022. Now, in late 2022, DC passed an amendment to the tree law, another one. And what this did is allowed us to put moratoriums on properties in the event that trees were removed, willfully or, kind of with malice, and which I think definitely would apply in this case. But unfortunately, the law just wasn't active at that time. And so we couldn't put a moratorium on this property. We do have a case, a similar case that's involving the same registered consulting arborist, same expert witness, different property, different developer. So, there's kind of sort of like bad seeds are running together. But in that case, I think we're waiting to get a result from the hearing. And if we do, we win the case, then we're going to put a moratorium on development at that property.
Someone from New York City said it was an eerily similar situation to what they've dealt with and the method in a poisoning case in New York City, and wondering if there's some sort of how do they learn this? Have you heard anything? Is it just kind of it's maybe easy to figure out you could poison a tree, or have you heard of developers colluding and talking to each other to try and circumvent these types of rules?
Sorry, the closest we got is the sort of the man in the the shadowy figure. This arborist really didn't want to be. He did the correct thing and said, "Look, I don't want any part of this," to the developer. But when he told us the story, he said, "I don't want any part of this to us," meaning our investigation. He really just wanted to be a part of it, totally, to the point where in my write-up, I just called him Arborist One in the memo that I submitted to the court, because he was so sincere about his privacy. So that's the closest we've got. I think this guy, from what I can tell from when that happened, I think this developer just started, soliciting arborists for tree poisoning services, and finally hit on one who was like, "Hey, I'll do it for $1." But then once he found the right guy, then it went back to then he's telling other developers or other people in his orbit, this is how I skirted the law, or this is sort of the penalty you might face for removing a heritage tree, It's just a monetary penalty. So if you can cover it, you know, with cash, then you're good to go. And so, yeah, unfortunately, I'm not, haven't gotten inside yet. We don't have, haven't met the, the turncoat.
ringleader.
Yeah.
Wow. What about, you alluded to this about the trespassing and how you could go onto that property. Another question though, still about entering private property, gather evidence. So since you guys there was already permit issue, you said that opened you up to be able to do that. If there hadn't been that, how would you be able to, could you gather evidence?
We use a lot of different ways. So a lot of the time you would be amazed at how successful it is to just go knock on someone's door. Even if they're guilty and they know they're guilty, they might just let you onto the property, and then you can take a measurement and get the data you need to bring a case. That works. Again, like I said, it works a surprising amount of times. Even if we don't have access, there's still things we can use. We use a tool called Cyclomedia, which is like Google Street View, but it has measuring tools like built in it. If we can't get that measurement, and even the tree is gone, if we can get a diameter measurement like in person of the stump, we can enter that into a trunk taper formula and interpolate a measurement of the tree at 4.5 feet in order to get the measurement on which the fines are based. Usually identifying the tree can be done with again, Google Street View, Cyclomedia, subscription software, or we also have a subscription to Nearmap, which is the overhead imagery. All the overhead imagery you saw in the presentation was from Nearmap. So if we use those, usually some combination of that will get us an identification of the tree and a size of the tree at 4.5 feet. Even if we can't get that, we still have some math that we use to just try to interpolate a trunk diameter size from the canopy and the tree height. We try not to lean on that. I haven't brought too many cases, on that, if any, because I think the methodology maybe could be vulnerable, but usually we don't get that far anyway. And the other methods we have that are more reliable can produce a measurement for us.
What about though, where you were going to gather the samples off the property? Did you address that? Or are you able to just go?
Yeah, we could have been, I think, maybe vulnerable for like seizing their property, where we, it's not our tree leaves, it's not our trunk tissue. I think we thought it was probably worth it to just take it and let the chips fall where they will. So, and in this case, they didn't do anything. I think I think it's probably pretty gutsy, or it would be, to bring a civil case in that instance and say, first of all, make a claim that you have an interest in the dead leaves and dead trunk tissue. And second of all, just, go to a court where, our defense would be, basically that, you were massively and flagrantly, violating a civil law. And that's why we did it. So between those two things, I don't think there was too much of a risk in, seizing that, that property, I guess. Mm-hmm. But I think the question that the person who asked the question is right, that's, is something that, we were sort of vulnerable to. And luckily it just worked out for us. And I would expect it. I expected it to work out for us, and it did. But, it might not always. So it's something to keep in mind, if you're going to do something like that.
Okay. Well, I'm actually going to start wrapping. We've got a lot of great questions in the chat, and I'm sorry we couldn't get to them all, but I know, John, you could ask questions about tree and law all the time. I know it's such a hot topic, and people feel under their depth because they're not attorneys. And so we're so fortunate to have someone like you who's an attorney and also understands trees. So I think maybe we'll come back to this another time with you if you're willing, or I know there's a couple others in the forestry world that also deal with tree law. So we'll look to come back to this. I saw a couple other questions about how you guys determine your valuation on tree trunk, the diameter for fines. fines or the fine amount. And that's come up a lot. I know a lot of people have questions about tree preservation and how you would determine fines. So let's focus on a webinar on that sometime soon with DC, or I know other cities are pretty advanced on doing that as well. So we are going to wrap now. This is being recorded. I will share it with you. I'll follow up, and maybe John will help us answer some questions if there's something really specific via typing too after this as well. So thanks, John. Thanks, everybody. Really appreciate members being here. If you're not a member, please join soon, and we'll see you at the next webinar. Bye, everybody.
Thanks, everyone. Bye.